Hello landlords, it's Ernie Garcia, your landlord attorney. Today you will get my reaction to an actual eviction trial. Let's get started. What you'll be watching today is footage from an eviction trial, and you'll see the testimony of the plaintiff, you'll see the testimony of the defendant, and then you'll hear my comments based on what they've shared. Now, the jurisdiction of this particular court is definitely outside of the state of Texas, but I will be applying Texas law to these facts and my opinion as to what I think a Texas court would say based on this situation.
When did you leave the property?
18th of January, 2014. He texted me saying, I want you out the property.
He texted you saying he wanted you out the property?
Yes, Judge.
Okay, so right from the start, the problem with this particular situation has to do with the delivery of the notice from the landlord to the tenant. Clearly, a text in the state of Texas is never going to constitute proper notice. Chapter 24.005 of the Texas Property Code essentially gives three good ways to serve. It gives a fourth terrible way that I never advise, but those three ways happen to be in person, placed in the hand of the tenant or an occupant over the age of 16. You can also affix it to the inside of the main entry door. The inside, not the outside. If you open the door and can attach the notice to the inside of the main entry door, shut the door, you have left good notice. The final way is to send it by regular and or certified mail. Our recommendation is always to send it by both regular and certified mail, knowing that the certified mail can be tracked and the regular mail can never be properly rejected. Those are the three ways that the notice to vacate can be served. Anything other than that is just likely not going to count.
When was that?
That was in December.
And the reason for that was because you had decided you weren't going to pay the full rent.
That's right, Judge.
Because it was freezing.
Yes.
And because Simon acknowledges that he has an overriding responsibility as a landlord. And so as far as you were concerned, you weren't prepared to pay full rent for a property which wasn't fit for purpose. What was in the text message?
He said, you've got a week to get out. And he said, if you're not out within a week, I'm sending my boys round, change the locks, and all your stuff will be outside.
Okay. Here's another problem. You cannot choose this kind of self-help remedy. Again, there are legal ways to ask or command a tenant to leave. It's the notice to vacate. And you give them 3 days in the state of Texas, as long as it's delivered in writing, and as long as your lease doesn't require any more than 3 days. You send the notice to vacate, you make sure that it's delivered properly in one of the three ways that I described earlier. That's going to work out best for you. And once you've delivered it, you can say, if you're still there after the 3 days, I'm going to file a lawsuit. But the idea that you can go and physically remove any of the property belonging to the tenant, or that you can send someone over, as implied in the statement given here, to forcibly remove them, that just doesn't happen. The forcible removal of a tenant can only happen if the court has allowed it, and they only will allow that after a final judgment in an eviction, and only then after you've obtained what's called a writ of possession. If you, the landlord, have taken none of these steps, you don't have the right to forcibly remove anybody from property, and it really doesn't matter how much they owe in back rent. Landlords, let me know if you have liked this video. Click the like button if that's the case. If you haven't subscribed yet, please consider subscribing.
Simon, do you remember sending a text to the effect of, I'm going to send the boys round?
Yes, I do.
How do you feel about that, Simon? This is a family in a house. Have you got a family, Simon?
Yes.
How would you feel if somebody threatened your family? Huh?
Not very happy, Judge.
Oh, you're a master of the adjective, aren't you?
Now, while this is an attention getter, the fact that there is a problem with the rental unit is not in and of itself, in the state of Texas, a legal basis for withholding rent. There are procedures that a tenant can follow in the Texas Property Code. Chapter 92.056 of the code explains what rights a tenant has when they are seeking the remedy of repair. If a tenant has in fact followed the very strict procedure in 92.056, there are remedies available to that tenant, but one of them is not just the willful withholding of rent. That simply is not allowed. There are steps that a tenant can take. If the tenant hasn't taken any of those steps, they don't have the right to act really in any way against the landlord. The rent would still be owed even if there was a defect on the premises that the landlord knew about. In fact, in most cases, the fact that a tenant has not paid rent erases the obligation or the duty of the landlord to make a repair.
Asked me to calm down, which I did.
But it wasn't just the boiler, because there was a fire as well. The sooty fire. Tell me about the fire, please.
It was checking out black smoke on the chimney breast, on the outside of the fireplace. There was black smoke, which the gas shouldn't have been emitting.
Now, that can be very dangerous.
Very.
And it's not just because it's an open fire and you've got children around.
Carbon monoxide.
Which can be lethal. Terribly dangerous. Was that fire replaced, Rebecca?
No.
Okay, so again, in the state of Texas, the failure of the landlord to make a repair, even one that affects the health and safety of an ordinary tenant, typically is not a good defense in an eviction. But when you have a dangerous situation, again, it's a matter not just of the law. The Justice Court is a court of equity, which means if something sounds or smells unfair, the court can deny you the remedy that you're seeking. The fact is, if you put your tenant's safety in danger by refusing to make a repair, the court's likely not going to help you. Your best bet always when you have a dangerous situation on the premises is to fix it. It doesn't feel good. It doesn't sound like good advice or maybe the thing that you really want to hear. But number one, you want to take care of your property. And number two, if you are putting tenants in danger, particularly small children, that never sounds good in a trial. It's likely going to pull on the heartstrings of a judge, and you're likely not going to get away with it. My advice, if you've got to repair something important, something that again threatens the health or safety of an ordinary tenant, get it done. Take away any of these possibilities. Take away any of the sad story element from a defendant's presentation in the court. Once you do that, you then hold all of the cards because you've done everything that you've needed to do in accordance with the law. And even though some of these things aren't legitimate defenses in an eviction, they can come and bite you in the rear if it turns out that the situation looks bad enough to make the judge rule against you.
How did it feel, Rebecca, when somebody threatened your family?
It's not very nice. It was in a nice position to be put in. We worked hard on that house too, and to have to leave. My nana just died as well. It was just before Christmas.
Okay, so this is another sort of element to actual trial. None of the things that the tenant said here, Nana just died, it was right before Christmas, the statement wasn't very nice. None of these things are legitimate defenses to non-payment of rent. However, when you're dealing with actual people in a real courtroom, you're going to get a judge who isn't going to like the fact that you threaten somebody, particularly you threaten them in a way that you cannot legally enforce. These tactics never look good. And if you're called on them, if the court finds out that you've been utilizing illegal and unethical tactics, even if you have everything else in order for your lawsuit may fail strictly on this basis. Remember, you're dealing with real people. And if you try to skirt or go around the law or bend the law just a little bit, you may find that you've broken it, at least in the eyes of this court. And if that happens, you will not get your eviction.
Yes.
Are you thinking about answers?
No, I'm not, Judge. No. Yes.
No? Yes?
So naturally, landlords, we want you to make better decisions than this particular guy did. Always send notice in writing in accordance with Chapter 24 of the Texas Property Code. And when you're dealing with repairs, make sure that your repairs are not a stumbling block to your eviction. If there's something that materially affects the health and safety of an ordinary tenant, make sure you are handling it in a diligent way. You want to take away any possibility of any kind of sad story argument that your tenant might present at trial, so that you are holding all the cards and the court has no option but to grant the relief that you're seeking. If you are interested in watching additional content from this channel, YouTube seems to believe that this video is good for you. Also, if you haven't yet subscribed, there's a picture of me on the screen. Click it and you can be one of our many subscribers. And until next time, happy leasing.